Sounds good. I want to thank you for joining, and Sean, thank you for putting this together for us. Um, Sean, if you don't mind, if you see something pop up in the chat and I don't get to it right away, just kind of maybe catch my attention. I'll look because sometimes I may not see it as I'm talking through and going through slides. I do want to preface this. Again, I am Christian Beiter, financial advisor, certified financial planner, and a certified exit planning advisor here in the Tampa Bay area in Florida. That being said, my goal today is to give you some information that's going to help you when you go to meet with your tax person, your legal person, your financial person, so that you know what types of questions to ask. And so, in a lot of my slides, as I do this workshop regularly in Florida, I do them at different community colleges. Um, it's going to have Florida information, but I'll let you know that some of the rules may be different in other states. But again, the point of this is just to give you some things to think about when you go and talk to your people to make sure, your professionals, to make sure everything's going the right direction and you have everything set up. Okay. So, all right. So typically when I start my workshop, I give an analogy of based from an article in the Scientific American. And according to the article, among those that died while climbing Mount Everest, they passed away climbing Mount Everest, 56% died after they made it to the top. So they reached their goal. They made it to the top of Mount Everest, okay, and then died on the way back down. But another 17% died after realizing, hey, we're not going to make it. Let's turn back around. We'll do this another time. So only about 15% of those died on the way up. And the point of this is I use it to compare it to retirement. Your goal is to get to retirement for most people, and that's like getting to the top of Mount Everest. However, if you don't make some right decisions, you don't do things correctly, then you can destroy your hard-earned nest egg and retirement plan. Okay. All right. So preservation first, here's what we do. Again, this is just not to sell you, but just kind of give you an idea of what our backgrounds are so you know where we're coming from. We do a lot of different things, but my focus, a wealth advisor, focusing on estate planning. And you'll see towards the bottom where it says align with strategic professionals. The goal is that, or the point of that is to, as we go through this workshop, as I said before, you need to be talking to your professionals, your tax person, your financial person, and your attorney to make sure your estate plan's in line. Okay. It's a folder we normally pass out. I'm going to skip that. Disclosures real quick. All this is here, so I got to give this by law. It just says what we're going to go through today is general in nature. Everybody's situation is different. That being said, I'm not giving specific legal advice, specific tax advice, specific investment advice, because again, everybody's situation is different. So what's the purpose of estate planning? Okay. Estate planning is a map of how you want your legal, health, and financial affairs handled in case of incapacity or death. Typically, when people come into the office and they're talking to me about estate planning, it's usually for one of three reasons. Number one, they want to leave a legacy. They want to pass down what they've built to kids, grandkids, their community, their favorite charities. They want what they've built to better other people's lives. Okay. Second reason is they want to provide financial support. Hey, Christian, I want to make sure my husband is taken care of if something happens to me. Hey, Christian, I want to make sure something happens to me, my kids are well taken care of. Hey, Christian, I have a special needs child. I want to make sure they're taken care of if something happens to me. Okay. And the third reason is just to keep it simple. If you've ever had to handle an estate for somebody and it isn't well put together, it could be very time consuming, emotionally draining, having to handle and deal with the estate and handling the process, getting phone calls from people. What's taking so long? Why haven't I got my money? Why is so-and-so getting the house? I thought I was getting it. So people come in and they want to just make this an easy process for their family, make it as smooth as possible. Right? So we go through, we're going to talk about two parts of estate planning. One is the legal side. That's what most people think about and care about when they're thinking about estate planning. It's the documents, wills, trusts, power of attorneys, all those documents. Okay? Usually done by the attorneys. Second part, though, is the strategic side. And part of that is the goal is, again, to protect what you built, make sure you're protecting it from lawsuits, from healthcare issues, from taxes in the IRS. Okay. And that's where it comes very important that you have a collaboration between those professionals that we discussed. Okay. So we're going to go through and we're going to talk about why do you need some of these documents. We're going to talk about what is probate. How can my family avoid probate? Okay. Then we're going to talk about what documents you need, talk about some special considerations, and then wrap up with some taxes and how to handle them, how to manage and lower them. Okay. So why do I need estate plan documents? Some of them are for avoiding probate. Some of them name your heirs, who's going to get what, designating who's going to handle it through your will. In Florida, we call it the personal representative. But who's going to manage your trust? Who's going to take care of the estate after something happens to you? Some of the documents for incapacity. What if you can't make your own decisions? Some of them are making end-of-life choices. What if you end up on life support? Do you want to be on life support? What about a DNR? Do you want to be resuscitated? Some of them will create rules, make plans. Some of them are used to manage taxes and give direction to family. And the goal and hope of doing this is to prevent or reduce legal costs. Okay. So what happens if you die or become incapacitated without an estate plan? Okay. States have what they call intestacy laws, and they vary from state to state. And basically what that is the states have an order, like, hey, if you pass away and you don't have your affairs in order and we have to make decisions because you didn't provide the state, you didn't provide your documents to be able to do that, so you don't have your will, you don't have your beneficiary names or whatever it may be that would handle your probate process and the passing of your assets. The state has an order and rules in place of how they will pass it on. Okay. The problem with that is it becomes more expensive because now there's more attorneys involved. Okay. And also some of your wishes may be irrelevant. So for example, maybe you have a niece or nephew in your family that you want to leave some money in addition to your kids. And you don't have it documented correctly and it has to go through the intestacy process. Here in the state of Florida, for example, typically it goes spouse. They're going to pay the spouse first, especially if it's a first marriage, assuming it's first marriage. Then kids. And then usually if you don't have any surviving kids, and then it goes back up to parents, and it goes down to brothers and sisters. So they have an order, and it just keeps going from there of who would be the next in line to get paid if no one from the prior line is still alive or able to be found. Okay. But say you have a niece and nephew that you're really close with, and you want them to get some money as part of your estate, and you don't have it documented. Well, in the example the order I just gave, for example, in here in Florida, I never got down to niece or nephew because they're further down the list. So your niece or nephew would have been disinherited in that example, even though you wanted them to get something. Okay. So it's important that you have the documents in place to avoid the state from determining who's going to get your assets versus not. And you, for example, it may be a second marriage. And you may want all your money to go to your kids, but again, you don't have it set up correctly. And here in Florida, usually it goes half to your spouse and then half to your kids. Okay. So again, that may not be the order. You may not have wanted that split, but that's what they're going to do because they don't have anything stating otherwise other than the laws that they have to follow since you didn't provide them. Okay. So what is probate? So probate is the court supervision of the transfer of a deceased person's stuff after death. Basically, it's death court. Okay. And it's the process of bringing together your assets with your creditors. And it's a formal method of informing the world of your passing. So here in Florida, for example, we have a 90-day creditor period where it's publicized that you've passed so that your creditors have a chance to put a claim in on your estate. And some people, when we do this, will say, oh, well, I don't have any creditors. I paid off my mortgage or mortgages. I paid off my credit cards. I paid off my cars. I paid off everything. I have no debt. That doesn't mean you won't have creditors. You may have hospital bills. They're going to want to get paid after you pass, even if you haven't paid beforehand. Say you have a landscaper. Landscaper does work in your yard, and then you pass before they get paid. Now that landscaper or his or her company is a creditor. Okay, so you'll have creditors. Now, the downside of probates are many. Okay? So it's time consuming. As I mentioned, here in Florida, we have that 90-day creditor process. Down here, you're looking at 6 months on the good, easy side. Typically, we see it about a year. And part of that process, it delays the disbursement. Part of that's going to pay the creditors. You got disputes you got to handle. What we're going to talk about, it tends to be pretty avoidable. There's a lot of steps you can take to avoid probate, and it can become very expensive if you don't. So we'll start off with like the costs. And here I'm using this as the cost of in Florida as the example. Again, if you're not in Florida, these numbers vary, but I'm just using this as an example here to give you an idea. So in Florida, if attorneys want, they can charge based on the size of the probatable estate. So how much assets you have that have to go through probate. And here's a chart, but the grand scheme of things, to make it easy, rather than trying to memorize the chart, just think of it as roughly 3%. So if you have $300,000 of assets that have to go through probate, think about it as $9,000 of fees. Okay, that's if the attorney wants to charge you based on size of the estate. Okay, here in Florida, we typically see one of three ways. One being this way, doing the size of the estate. Two is a flat fee. We don't see that very often. Reason being is because if you do a flat fee, or if the attorney does a flat fee and the estate ends up taking more time or work than they thought, they've already locked in a price and they'll be working for less than what they would plan to. The most common way of doing it, typically we see here in Florida, is is hourly. In the area we're at here in Hillsborough County, Florida, over Tampa area, is normally I see between $300 and $450 an hour. And the attorneys that I see around here charge in 6-minute increments. What that means is they're charging you at 1/10 of an hour at a time. So if you make a 2-minute phone call to them and they talk to you for 2 minutes, they're going to round up typically to the 6 minutes, so 1/10. So if they're charging you $400 an hour, that 2-minute phone call just costs you $40. And they're tracking every time they send an email. They're tracking every time they talk to the other attorney. They talk to you, that they're doing research, scheduling, court dates, whatever it may be. They're tracking the time it takes for them to do it. Okay. A lot of times, I was having lunch recently with an attorney down here, and he was saying what he's seeing commonly now is when the client signs the agreement for probate, in the agreement it says, hey, we're going to track the percentage or the cost based on the percentage, and we're going to track the cost based on if we did it hourly, and you're going to pay the higher of the two. So they're going to get you whichever comes out higher. Okay. And what we're talking about, that's just the attorney fees. Okay. So as we said, probate can be expensive. So now how can my family avoid probate? So we're going to talk about a couple steps you can take. Proper titling. Should the account be with a joint account? Here in Florida, if your spouse is on or someone's on as a joint with rights of survivorship, when you pass, the person who inherits, the person who's on the account automatically takes over. It's theirs without going through probate. One of the concerns with that is there's a couple. Start off with creditor concerns, especially, again, I'm using Florida's rules down here, maybe different where you're at. But for example, here, I have people come into the office and they'll mention, oh, I put my daughter on my account. I put my son on the account because I want to make it easy if something happens to me. Okay. Well, say your son or daughter is happily married. This example, I'll use your daughter. Say your daughter's happily married, and then all of a sudden, she's not. So now your future ex-son-in-law goes to his attorney. The attorney says, hey, I need a list of all the assets and accounts and everything that you or your wife are on. And he remembers she's on the account with mom and dad. Well, now, because you put them on as an owner, guess what they are? They're an owner. They have the rights to go into the bank and take money out, to write checks, to make changes to the account as if it was you because you made them a joint owner. Okay. So now you're putting your assets at risk if they were to get in a divorce situation, or if they were to get in a situation where they get in a car accident and now they're getting sued. Okay. Again, by putting someone else's name on your account, you open it up. The second part with the titling, and it's going to be similar with beneficiaries and such, is if you have say you put your spouse on the account as a joint owner, and it's a second marriage, and say you wanted your money or at least some of it to go to your kids that you had prior to the marriage. Okay. And you put them on as a joint owner with rights or survivorship, and you pass away. Well, guess what? Now they take over, your spouse takes over that account and it's theirs. And now wherever they want it to go, it's where it's going to go. Okay. So you could be disinheriting people that you wanted to get money. The next thing we're going to talk about is beneficiary designations. Okay. So are they accurate? Are the policies up to date? A lot of times people come in the office and we'll be doing a review. And I'll say, oh, good, you got John here as your beneficiary. And they'll be like, well, John passed away 3 years ago. Well, then John's not a very good beneficiary. We need to get that updated. Okay. So make sure it's up to date. I read an article a couple years ago about a person who was got out of school, went to work. At the time didn't have kids, wasn't married. So he named his girlfriend as the beneficiary. Okay, named his girlfriend. 35 years later, he passed away. Never updated the beneficiary form. Okay, never updated the beneficiary form. So now, in his documents, because he never got married, never had kids, in all his other accounts, documents, his brother was his beneficiary. Okay. And so the brother found out he's not the beneficiary of that account and filed a lawsuit to get the money. Well, the courts ruled against him, ruled in favor of the girlfriend. The girlfriend from 35 years earlier. And basically the reason why is because how are they to know what your intentions were other than what they have documented? And what they had documented was for the ex-girlfriend. So that ex-girlfriend from 35 years earlier ended up getting an inheritance, a windfall that she wasn't expecting of $750,000 from that account. Okay. So make sure you're updating your beneficiaries. Okay. The next thing is secondary or contingent beneficiaries. If you have the ability, a lot of accounts will allow you to name a secondary or contingent beneficiary. And that secondary contingent beneficiary, same thing. It's just a backup plan. So a lot of times we'll see spouse as primary and kids as secondary, or kid, son, and then a brother, or however you want it to be. But if you have the ability to name a secondary, that's a backup plan in case, God forbid, your primary predeceases you and you never get around to updating it. Okay, so make sure you're updating your updating beneficiaries, and if you have the ability on the accounts, name a contingent beneficiary. Okay, so are there beneficiaries? What types of accounts allow you to name beneficiaries? Okay, so your banking products will normally allow you to name beneficiaries to what they call a POD, or payable on death designation. Okay, your non-retirement investment accounts. So like if you have a brokerage account or Robinhood that you set up that's not a retirement account, those will usually allow you to name beneficiaries to what they call a TOD, or transfer on death. Okay. Your life insurance, your annuities, your retirement accounts, whether it's an IRA, a traditional IRA, a 401k, a 403b, a thrift savings plan if you're a government employee, all those types of accounts allow you to name beneficiaries. Okay. So those, I didn't list real estate. It's different from state to state. Like, for example, here in Florida, you can't name a beneficiary on your property. You have to go and there's steps you have to take. You either have to put the property in your trust, or you have to do what they call a ladybird deed. And there's pros and cons to each of this. So talk to your attorney about the options of beneficiaries or how to avoid probates on your home. But here in Florida, you can't name a beneficiary on real estate. You have to, again, either put it in the trust or put what they call a ladybird deed, and the ladybird deed allows you to name the beneficiary. You have to file that through the state, file that with an attorney that then gets filed. Okay. Yep. So ladybird deed, especially and down here in Florida, and they may have different terminology for it in other states, but here in Florida, ladybird deed is a form that you have done by your attorney that gets filed, and it allows for you to name who the beneficiaries are, who is going to inherit the house without having to go through probate. So if you wanted to go to your 3 kids, you put them down, and that gives you the right to live in the house. And then when you pass, it's going to the kids. Okay. So what we're seeing here in Florida is more, we're seeing that there maybe sometimes there's issues with that, like when a person goes to sell their house, that now the beneficiaries have to sign off on it. It's not supposed to be that way, but I'm hearing it from attorneys. I've heard it from multiple attorneys that that's starting to happen. So just be careful on that. But it is a little bit lower cost than doing the trust. But again, here in Florida, if you sell a property and you buy another one, you'd have to do a whole new ladybird deed. So each time you sell or buy, you'd have to do a new one and pay for it again. Or God forbid your beneficiary predeceases you. You have to go there and you may have to file a whole new ladybird deed to update it. So it's just a document that's done with the attorneys, at least here in Florida, that allows you to name beneficiaries on it. And so sometimes people will use that as an alternative to a trust. Last part of beneficiaries I want to talk about is the per stirpes versus per capita. Okay. Per stirpes means through the bloodline. So give you an example. Say you have your kids as your beneficiary. Okay. You have your kids as your beneficiary. And say each of your kids have kids now. So you have, in this example, I'll make it easy, you have 2 kids, and each of your kids have 3 kids, 6 grandkids. Okay. If you have it set up as per stirpes, so you have your 2 kids as primary listed as per stirpes, God forbid one of them predeceases you. Okay. If one of them predeceases you and you never update the beneficiaries, then now when you pass, your grandchildren of the deceased child, so your grandchildren through your deceased child, would now split their share between the 3 grandchildren. Okay, so it flows through the bloodline down, not to the spouse. Okay, not to the spouse, through the bloodline, and that usually includes legally adopted or bloodline. I think I had a question. Let me see if I can see that real quick. So the question is, if I'm not using the ladybird deed and have a trust with their home, what's important for me to know the structure of the trust? I'm going to get to trust in a little bit, so I'll give a little more details on stuff as we go through the trust on that. So I will get to trust in a few minutes. Okay, but great question. So again, per stirpes is going to flow through the bloodline. Okay, per capita, same example. You have 2 kids. They have kids. God forbid something happens to one of your kids, they die before you do, and you don't update your beneficiaries, now your surviving child inherits 100%. And your grandkids through your deceased child would get nothing. So they would have been disinherited. Okay. Neither are right or wrong. I have clients who come in and they want one, and I have clients who come in and they want the other. It's okay. Just make sure you have it set up the way you would want it.
I,
And
I
what
have a quick question on that.
Yep.
So you said that, so if your grandchild or whatever, how do you make it to where if you have your, you were saying your like if the grandchild has it, the beneficiary, how if your grandchild, what if your grandchild's underage, but you don't want the parent to control it?
So typically
Yep.
in your legal documents, you're going to have who would be, you can list who's going to manage the money until their legal age of majority. So here in Florida, for example, is 18. A lot of states is 18, some states is 21. Once they turn that age of majority, the money's theirs. So you would want in your legal documents, for if you have them, if you don't want them to get it at that age, you can put it in the trust. Hey, you can receive the money when you turn this age or when you do these things. So I'll give you some examples on those in a few minutes when we get to the trust.
So
But if
so
not, the
so
money gets set aside and someone's responsible for looking over it and using it for the grandkids' behalf, but it's there, and then the grandkids would get it when they turn 18.
so if your grandchild is 1 or 2 years old or 5 years old, but you don't want, say if something happens to you and it goes into their possession, but since they're a minor, you have to have it in a trust, or do you, when you put it as in just, if you're outside of a trust, how do you delegate it to where if you're not in a trust, to where the parent doesn't control it because they're a minor, if they're only 5 years old or 2 years old, how do we set that up without being
So
in a trust?
So normally it's going to be the court will decide who's going to, if you haven't dictated in your, like your will and your legal document, who's going to manage the affairs for them. Usually it's the court's going to choose their parents unless they have a reason not to. And then it's kept in account for them and to be used for their benefit. And then again, when they turn legal age of majority, it becomes theirs. So you don't have to have the trust for it to be set aside for them.
Is it
But the
easier to
trust,
be within? Is it easier with the trust to set up the rules just in for whatever? Is it easier
yes,
to have the trust? Yes.
the
Okay.
trust will allow you to set the rules on how they get the money
Okay.
and under what circumstances. And I'll give you a couple examples in a few minutes when we get to that. But
Okay.
yes, usually that's if you want, because most people don't want anybody getting the money before they're 18 or at 18. Yeah, they don't want it getting at 18 because they're worried about it being spent or being used stupidly and not managed correctly. So you can put limitations in place with the trust. And like I said, we'll get to that in a few minutes. Okay. So, yep. No, go ahead. So great question. Yep, great question. And the per stirpes is for a bloodline or legally adopted. If you have stepchildren or foster kids you take care of, that per stirpes will not flow through to them. If you want them to receive something, you got to specifically name them as a beneficiary. Per stirpes won't flow through to them because they're not legally blood or legally adopted. They're not blood or legally adopted. So if you have a bonus child that you want to receive it, you can. You just got to say, hey, Junior gets 10% or gets 10,000 or whatever you would want them to get.
So
Okay?
how does it go if so I have, but my situation, so I have multiple stepchildren and I have my own kids. I have grandkids and step grandkids, right?
Yep.
I'm not legally married, but how do I, but I mean, me and my girl, we live our life as we're married, but
Yep.
how do I have that set up to where like her, like you said, by blood, um, kids are still all like how everything is all. I have to set that up. Like, is it easier just for me to be married, or do I have to, if I'm not married, then I have to set it up like verbatim by each, like,
So you would list, because even if you're married, they're not your blood unless
wow,
you'd have to legally adopt them. So you could go ahead and say, I want my three stepkids, I'm just making up the numbers now, to each
right.
get 20%, and then my two kids to get 20% each. And you can list them and include them. But if you don't, and you they're not legal, they're not blood or legally adopted.
Even
So you wanna
even if she is the main beneficiary of all the accounts.
So you could put her as the beneficiary, but if you put her as your primary beneficiary and you say per stirpes, it's going to flow through to her legal children, not yours now. Now you just excluded yours
Wow.
because
Yeah.
Are they coming back tonight? What do you mean they don't come? Oh,
Yeah, because we're not all blood, but we are all family. So it's like we're not all blood technically, but we are all family technically. So it's like, I mean, I have my kids, she has her kids, she has grandkids, I got like it's a whole big, like, it's a
yeah,
clusterfuck, but
I,
it's all a one though. It's
yeah,
all
no, and I
one.
understand that, but the courts don't recognize that typically. If you're not legally married and they're not legal and you don't legally adopt them, they're not your kids. So if you chose, again, go into example, and I'll continue on just so I can get through to the other parts and we can maybe readdress it when we get to the trust and see if that helps any. But if you leave it to her, for example, as your primary beneficiary, okay, and you say per stirpes, it's going to flow through to her kids because you need her as a beneficiary. She's now passed. When you die, she's already been deceased. It's going to go to her kids if you did per stirpes. If she's still alive when you die and you leave it to her, now it's whoever she names as beneficiaries. So whatever you wanted becomes irrelevant at that point because you left it to her. If you wanted it to eventually go to your kids, she could disinherit them. She could spend it all. She could do whatever she wants. And I'm not saying she is. I'm not. I'm just
Right. No,
giving
no,
you
no, I understand. No, no, I
yeah
understand.
the legality
Right.
of it. Okay. All
Right.
right. So yeah, and like I said, let's keep going on that. We'll keep going, and we can address that maybe as I explain some of the options within like a trust that may help you with what you're trying to accomplish.
Okay.
All right, so how can my family avoid probate? Continued. So the next thing is a trust. I'm only going to talk a second about a trust here. I'm going to come back to trust in a little bit, but I want this. The trust is a way to avoid probate. So the trust must be funded to avoid probate. What that means is people come into the office sometimes and they'll say, "Hey, Christian, here's my trust documents," and I'll look at it. I'll say, "Great. Who is your what's in the trust?" And usually they'll tell me, "Oh, everything's in the trust." And then they show me their statements. And I look at their statements and it says, "John and Jane Smith, John Smith, Jane Smith. Those are the account holders." Then we'll go on to the county website and look up their property, and it will say owner John and Jane Smith. You know what that tells me? Tells me it's not in the trust because if it was in the trust, on the statement it would say the John and Jane Smith Revocable Trust or the Smith Family Trust. Okay. Because it doesn't say that, it has their names, that usually means it's not in the trust. Okay. So it has to be funded in the trust. And to give you another analogy, say you go home and you have a safe in your house and you take your valuables and you put them on top of the safe and you go to bed. And that night there's a fire or the house is robbed. What did that safe do for those valuables? Nothing. Very similar. That's how a trust works. If you don't put the assets into the trust doesn't do anything to help you when it comes to avoiding probate. The trust, and the trust will distribute them the way I want to. So it's a safety net. So just because you have a trust and just because you've set up all your beneficiaries doesn't mean you don't want to have a will.
okay, thank you.
Okay? No problem. All right. So what documents do you need? Okay. You want to plan documents for planning incapacity and documents for planning for death. So let's start off with planning for incapacity. And again, they may vary. They may vary in your state, but the point of this is to kind of to know, like when you talk to your attorneys and such, you're asking these types of questions. Okay, well, what documents do I need to handle this? Here in Florida, you have your healthcare directives, and I know a lot of states use similar documents. You have your healthcare directives, which is typically made up of two different forms. One is your healthcare power of attorney. This is who the doctors are going to talk to if you become incapacitated or you can't answer the questions yourself, or if they need to, if you have questions. Okay. Without that healthcare power of attorney, if you go to ask questions about someone, they can't answer it. They can't take your direction. Hey, I'm his power of attorney. I say this is the treatment we want. They don't know that if they don't have that healthcare power of attorney, they don't know that. Okay? So that's who the doctor will take direction from. That's who they'll give information to, the healthcare power of attorney. You also have your living will. Your living will allows you to direct how long, if at all, under what circumstances, you would want to be on life support. In Florida down here, we had the famous case that actually went national of Terry Schiavo. Okay. Terry Schiavo went into a permanent vegetative state. Her husband said she would not want to be on life support. Her parents stepped in when they went to take her off and said, no, she would not want to be on life support. I'm sorry, she would want to be on life support. I'm sorry, she would want to be on life support. So husband said no, parents said yes. They went back and forth in the court systems for over 12 years. Think of all the extra legal costs. And then think about, we don't know what her wishes are, what they were. We don't know if she would want to have been taken off right away, or we don't know if she would have wanted to have been on life support for another 15 years. No one knows what she wanted because it wasn't documented. She didn't have the living will, or at least no one knew where it was if she did. Okay. So that living will state whether or not, or under what circumstances you would want to be on life support. Okay. And then the last document we're going to talk about when it comes to planning for incapacity is your durable power of attorney. Okay. That's who's going to make your financial decisions, your business decisions, your legal decisions. Okay. Again, down here in Florida, you need to make sure it's durable. If it's not durable, when you become incapacitated, the document ceases to be any good. Okay. The durable power of attorney is the one that you're given the power to handle your affairs. They can talk to that's who will talk to the IRS. That's who will be able to go into the bank and open accounts or pay bills or talk to Medicare and Social Security on my behalf. That's who you're giving the power to handle those affairs. Okay. They got a couple questions pop up. One about trust. We'll get to that in a minute. All right, so now planning with death. We talked about wills, okay? Just real quick, again, you got to name in the will, you name who's going to handle everything for you. Here in Florida, we call it the personal representative. That's who's going to be responsible for going through the process, okay? Typically requires your probate. Okay. Takes a while. In your will, you'll name, after the probate process is done, you get to say who's going to get it, who's going to receive the assets, and under what percentages, and they'll get. Okay, so a will is good. It helps, but again, it's part of it's going to be used during probate. The other way we plan for death is with the trust. Okay? Revocable trust. Okay? Keyword is revocable. Means you can cancel it. Means you can change it. Okay? You can take stuff in and out relatively easily. The reason why people typically do trust, number one, as I mentioned before, for revocable trust is they're trying to avoid probate. And number two, the trust allows you to put limitations in place. Okay. So going back to your grandkids, for example, you don't want them getting it right away. You could say, hey, you can't get the money until you've either graduated college or joined the military or went to a trade school. So if until they do that, they have no access to it until they accomplish one of those things. You could say, hey, you can get 25% of it at 25 and the rest at 30. You can get money for a house purchase. I had a lady attend one of my workshops, and after the workshop, she came up to me and was talking to me and said, my dad was a very big gun enthusiast. He put in the trust, I can't get access to the money unless I get my concealed weapons permit. Because he wanted her to do that. She didn't have to, but she didn't. She wasn't going to get access to the money in the trust. I had another person come into the office, and they were putting what they called, or what is called, they didn't call it, but it's what is called a beach bum provision. The beach bum provision basically that's not a legal term. That's just like what it's called, and we call it. Basically, it was his daughter was only going to be able to get money based on how much money she earned, because he was worried when he died, she would just live off the trust and not do anything and just be lazy and not contribute anything to society. So he was putting in there, for every dollar she makes, she can get 50 cents out of the trust. So if she made 100 grand that year, the trustee would cut her a check for $50,000 because he wanted her to keep working and doing things, not just live off of what he worked for. Okay. So the trust gives you all the ability to say, hey, if this person is alive, it goes to them. If they're not, it flows through. Or if this person is alive, or not alive when I pass, instead of going down, I want it to go over here and start going that way. So you can put in the trust who's going to get it under what circumstances based on who's living. Okay. And so it allows you the flexibility to control, or in the power to control who's going to get it. Okay. Because once you name a beneficiary on your like bank accounts or your investment accounts, or you have it in your will that these three people are going to split everything. Once you die and that probate process is done, or when the institutions pay out to the beneficiaries, you have no control. They do what they want with that money. The trust allows you to control and protect it. Okay. I want to point out, at least here in Florida, when you have a revocable trust, because of all that flexibility, okay, there's no creditor protection unless the asset in the trust is already creditor protected, like your homesteaded home. Okay, that has some creditor protection already, not because of the trust, but because it's homesteaded. Because you have all that control, just like it's yours, they look at it as if, hey, that trust isn't doing anything there's no separation there. It's really only being used for the probate process. Okay. However, the other option is an irrevocable trust. Keyword is irrevocable. It means it's really hard to cancel or to change once you've set it up and funded it. Okay. You have very limited access. It's usually only, okay, well, it can kick out money for your health care, for your living expense, your basic living expenses, stuff like that. In your revocable trust, if you wanted to sell a house and buy a Ferrari, or sell a house and travel the world, with your revocable trust, you have all the power to do that. An irrevocable trust is going to be much, much more difficult. And so people ask, well, why would you do that? Why would you give up all that control? A couple of reasons. One is creditor protection. You tend to have much more creditor protection with an irrevocable trust because it is a separate entity. So if you get sued, you don't own the assets in the irrevocable trust. The trust does. You don't own the irrevocable trust. You may be a beneficiary of the irrevocable trust, but you don't own it. So while it's in the trust, there's much more protections in it. Okay? So the other reason people may use an irrevocable trust is say they have a large estate. Currently, just like the gift tax exclusion, the lifetime that I mentioned, the estate tax exclusion is 13.99 million for an individual and basically double that for a married couple. So if you think you're going to have more assets than that, so either 14 million or 28 million dollars, then you can use the irrevocable trust as part of your planning process. For example, if you put $5 million into your irrevocable trust and 25 years from now you die and that $5 million in assets has grown to 25 million, that $25 million is not part of your estate. Well, what's the big deal about an estate tax? Well, any money that qualifies as having to pay the estate tax percentage is basically 40%. So you'd be losing 40% for every dollar above your estate tax limit. Okay, and that's just on the federal level. Many states have state level ones. Also, Florida does not, but many states do. Okay, so irrevocable trusts are again for creditor protection. You're a doctor and you're worried about if you get sued, or you have a lot of business dealings and a lot of debt, and you want to protect some of the assets you saved and built up from creditor protection. I mean, from creditors. Again, the concern is, you're losing and giving up access to that potentially. Okay. All right. So now questions. I know we touched more on the trust. Now we can kind of get more onto the specifics of questions if we have some.
Okay, I have a question.
Okay. So, yep.
Okay, so with if I was to create a revocable trust right now to where I can, the rest of my life or as long as I'm living, say the next, whatever, 20 years, whatever, I could change it how I want to change it. Can I put a stipulation in the revocable trust to where if I die suddenly, it becomes irrevocable? Can I do that?
Typically, it automatically becomes irrevocable at that point for the main purpose of preventing people from being able to make changes to your trust after you die.
Okay.
So it has in there, so whatever you put the rules in, unless they were illegal when you put them in, which that's what an attorney is for, to make sure it's not, when you pass, or both, or if there's two trustees, like say you do get married and you put you and your wife on one trust, once the second person passes, then the trust becomes irrevocable, so no one else can come in afterwards and change it.
Okay. So, and my next question is, my son, he was playing Little League football, right? So I'm sitting there on the bleachers and I'm listening to these people talk, and this one guy, he's got a bunch of shit going on around town, and he's also like a personal injury lawyer, and he's got a bunch of real estate. But then he's talking to this other guy who is an accountant for the family of, I don't know if you guys ever heard of, or I mean, I'm in Fort Lauderdale, so I know I'm in Florida too, but I don't know if everybody else around. I mean, if you ever remember the insurance, the General, you remember the General insurance commercials? Okay, so he was the accountant for that family, the guy who created that. Okay, and I remember hearing him talking about stories about when that guy died. His kids all started suing the shit out of each other. They were suing each other. They were suing the mom. The mom was suing the kids. All with all this crazy shit about how the trust was set up and this and that. So how do we avoid that? I'm sorry. Okay, yes, I'm sorry. I'm sorry. So how do we avoid what that man created? Like he created to where he had a trust with this kid gets that, this kid gets that, this kid gets that, the wife gets this. But when he died, they all sued each other. The mom, the kids, they were all at war with each other. How do we avoid that?
So sometimes attorneys will put stuff into the trust that says into your legal documents, that if you try to go against what's in the trust or try to fight it, you lose access to everything you were you're forfeiting your inheritance. So that's one way that they may put something in the discouragement. There's nothing that can stop them from doing.
I don't know if anybody else can hear.
Yeah, it froze
Yeah,
up.
he froze.
And so it
On
helps.
the first question, the second question froze up.
Okay, hold on. Let's. Yeah, I see Vaughn's. I was getting ready to go with. Um, yeah, yep. Yeah, and I was going to go through. Okay, so Luis's, if I'm not using Ladybird and have the trust with the home, yeah, so you're going to want them on the Ladybird deed. You can have it. You can either have the Ladybird deed go directly to the beneficiaries, or some people have the Ladybird deed say when they pass it goes to the trust. And so the trust documents will say this is how it's going to be handled for the surviving spouse. And usually, if it's like a joint trust, nothing happens until the second spouse passes.
Okay,
Does that answer your question, Louise?
it does. It helps.
Okay.
Yeah, thank you. And I did have one additional question, real quick, piggybacking on what Snook was just referencing. And I will ask the question this way. Do you give direction on how many layers down we can go when it comes to setting up a trust and or a will?
So
As an
I tell
example,
people go down as far as you know you want it to go. And then usually there's a what we call an ultimate beneficiary that says, hey, if none of the people above me, this is where I want it to go. And a lot of times that may be a charity or a church or something because you've named family down many, many lines. So it becomes a bigger deal the older you are, and the more likely that some of the people that you'd be leaving the money to are more likely to be passing away before you. But I would say I typically, and with attorneys I see go down as many layers as you know what you want it to be. Because
okay, because
but you
and
can always
thinking
go back. Remember, with the will and your trust, you can go back and change it. So if something happens to beneficiaries, and that's part of what I get to in a little bit as I'm wrapping up when we do it, is just because you've set everything up doesn't mean things don't change because beneficiaries unfortunately die. Beneficiaries get divorced. Beneficiaries get married. Beneficiaries have kids. So all those may change what your plan is. And as a plan, it's going to change. So
right.
you can make changes and you're going to want to make changes.
And I only asked that question because Snook gave a very real life situation. And when I think about from the standpoint that this is now becoming something in the front of my mind, okay, I'm not aware of but maybe one other family member who has ever thought about estate and legacy planning and trust. So when it comes, it's one thing to say that, oh, okay, I want to identify my son. I want him to get this. I want my granddaughter to get this. But just being even more detailed to take it down to every level of these are the specific things that I want them to do before they get this, because I don't want them to just blow it just because they become 21 and here they've got $1 million.
Yeah. Yep. So you can put you in part. I mean, the attorney that you when you meet with your attorney or your financial again, I would do it together or at least have them communicating in knowing what you have going on. That's where you can kind of come up with a plan under what circumstances you would want them to get them. I have clients who say, hey, they can get a third at this age, a third I'm locking up for the rest of their life, and they can just live off the interest, and a third that is going to be set aside for their care. And so, or again, you can do that. That's going to be between you and your financial advisor and your attorney to come up with a plan on how you would want them to get it. All
Thank
right,
you.
so
I
let's go on to the
appreciate
next one. Yep. Okay. All right. Vaughn asked a question. Don't want to get ahead, but what if it makes sense? Okay. So great question on the separate trusts. So if you and your spouse don't have this, especially if it's a blended marriage, but if you guys don't have the same ideas of what you want to happen with the money, then having a separate trust could be an answer to that. So if it's a second marriage and you say, "Hey, I want my money to go to my kids," then having a joint trust may cause an issue there. Okay, so it very well could. But if you've been married 30 years and you both say, "Hey, it's going to go to our kids 50-50," then you may not need the joint. You may just need the one joint trust versus two separate trusts. So it depends on your situation.
All right. Thanks so much.
No problem. Please explain the information. So on the joint bank accounts, what I had said real quick is if you have your joint own with rights of survivorship, you pass away, the joint owner with the rights of survivorship now takes over that without having to go through probate. Okay. And so if you wanted that money, especially again, in this example, if it was a second marriage, if you wanted that money to go to your kids and you die, but you have your husband on the account as a joint owner or whoever, it'd be whoever you put on, it doesn't even have to be a spouse. If they're on with rights of survivorship, that person now takes over that account. It's theirs to do whatever they want. So they can change beneficiaries, they can move it to themselves, they can do whatever they want because you left it to them. And so, okay, so the next one is, what happens if a spouse dies and that person didn't leave a will? They're going to go through probate. They're going to have to do the intestacy laws. More than likely, the intestacy laws are going to say, "Hey, now the spouse is the one who's going to benefit from it." Okay, so in Florida, for example, I don't know Georgia's laws specifically, but your local attorneys will. But in Florida, for example, you can't exclude a spouse. So even if you want to leave everything to your kids, if you're married, they're entitled to at least 30% of the estate. So you can't say, "Oh, you're getting my kids are getting all of it." So again, that's why you either want to, before you get married the second time, have a prenup, or even the first time if you already have assets. Okay. You want to have that all figured out in advance so they know that legally can help with that 30% exclusion. But if you don't have a prenup, they're entitled to 30% at your death. Okay. All right, so I'm going to move on so we can get out of here as close to this time as possible. All right, real quick, special circumstances. So if you have minor children and beneficiaries, this is kind of going along with what you had asked before, Snook, you can put limitations in place about who's going to receive that money, at what age, or under what circumstances. So again, they have to graduate, they have to do this, they have to do that. You can put limitations in place. Okay. If you have a special needs child, if you leave money directly to the special needs child or person, you may disqualify them from the benefits they're receiving. And you may think, "Well, I'm leaving them a bunch of money. They don't need those benefits anymore." Well, part of their benefits may not just be the financial side. They may be living in a community that they're doing really well and thriving in. And by leaving the money directly, they may no longer qualify to live in that community anymore because it's income and asset based. So if you have a special needs situation, your attorney can set up what's called a special needs trust. The money goes into that special needs trust and then pays the bills and takes care of the person on their behalf. But the money is not held by them directly, so set up correctly, it won't disqualify them. Children from a previous marriage. Again, if you go into a marriage, if it's a second marriage and you list your spouse as your beneficiary on your accounts, you now jeopardize your kids from prior marriage from receiving any kind of inheritance. But I have clients that say, "Hey, I want to make sure my kids get my money, but I also want to take care of my spouse." You can set up a trust that says, "Hey, if I die, the money's there for my spouse, and they can get X amount of dollars or X percent," or you can put how much they can get on a monthly or annual basis, and then it says, "Hey, however, when they die, now the money is available and passed down back to my kids. So while my spouse is living, they can benefit from it. But as soon as they die, now it goes back to my kids." And you can limit how much they spend or get, so they can't just spend it all right after you die. Okay. What if there's a significant age gap? we see a lot of times where now people are coming into the office and there's a big age gap. Hey, my wife is 15 years younger than me. Well, we want to make sure that it's planned if something happens to you that they have the money to get through retirement. Okay. What if there's a drug addiction, a gambling addiction, any kind of other mental health issues, alcoholism? You can put in the trust limitations. Hey, they can't receive the money unless they've been in rehab, or or they can only get the interest off of the investments. They can't get the principal, so you're protecting the principal. So you can do different things to protect them. Okay. All right. So we're going to wrap up here with taxes and how to manage them. Okay. It's hard for you guys to see. I'll try to enlarge it here. But normally I have when I'm doing this in person, I'll ask the question, who here thinks tax rates are high? And usually everybody in the room either nods or raises their hands or says, yes, it's high. But the point of this is if you look on this sheet here, so from 1944 to 1964, that's the baby boomer generation. During the baby boomer generation, when they were being born and raised, if you look, the highest tax rate was 91%. Okay. Can you imagine for every dollar you make, losing 91% of it to federal income tax? There's stories of Ronald Reagan before he became president and he was an actor. He would make a movie or two, get to the top tax bracket, and then stop working. Because he would go back to his ranch and stop working because there was no point for him to keep working, knowing that he was only going to keep 9 cents for every dollar he earned. Okay. So, however, looking at the chart, you have a lot of times where it's in the 70s, it's in the 50s, it's in the 60s, 39.6. Right now, the top tax rate is 37%. The point of this, and again, it's not political. The point of this, though, is to show that we're actually historically low when it comes to tax rates right now. Okay. Historically low. We got wide tax brackets and lower minimum than we've had in a long time. We're historically low. Okay. The point of this is that if we have historically high spending over here and we have historically low tax rates, what's eventually going to happen? Some point tax rates are going to have to go up. Okay? They can't cut enough to get rid of the deficit. Okay. So what that means though now, I'm just messing it back so I can keep going. Is we got to think about how to handle taxes. Let me change my screen. Yeah. Okay. So we have historically low tax rates. So what do we do to manage them? So how should your assets be distributed? Retirement accounts are huge tax liabilities for your beneficiaries. Okay. Huge tax liabilities. So if you have a thrift savings plan, 401k, a 403b, whatever type of retirement account you may have, except for a Roth. We're going to talk about Roth separately. But retirement accounts are huge tax liabilities to your beneficiaries for two reasons. Number one, they're taxed at higher tax rates than capital gains. So if you sell a house or if you sell a stock and you've held the stock for longer than a year, you get long-term capital gains rates. Okay, that's lower tax rates than ordinary income. That's why you hear people complaining about how the wealthy pay less in taxes because a lot of their income comes from investments, and those investments are taxed at lower rates. IRAs are not; they're taxed as ordinary income. Okay. Also, the other reason why it's an issue is say you bought a house. And you bought it for $200,000 and you've owned it for years and years and years and years, and now you pass away and it's worth $700,000. So it went from 200 to 700. Okay. And you die. Your beneficiaries, when they inherit that house, they get what's called a step up in cost basis. Their now tax basis is the $700,000 it was worth when you died. Which means if they sell the house, they will only pay taxes if it's above in the difference between what it was, the $700,000 or 750 in that. So yeah, 700. So if they sell it 2 years later for 800,000, they only pay taxes on the $100,000 gains from the 700. The other $500,000 in taxes or income growth appreciation is tax free at that point when you die. Okay. So if they sell it right away after you die and they sell it for 700, that $500,000 of gains, tax free because they get that step up in cost basis. Okay. Now, with a retirement account, say you have money in your IRA and you have $500,000 in your IRA and you die, your beneficiary cashes in that $500,000 IRA, they're paying ordinary income tax on the whole thing. They don't get a step up in cost basis like you did with your real estate and your stocks that are not in your retirement accounts. Okay? So retirement accounts cause big liabilities for your beneficiaries when it comes to taxes. Okay? Do you give assets away while you're alive or do you leave them to your beneficiaries? So that same example, you bought a house for $200,000, it's now worth $700,000. So you have $500,000 in gains. You decide to give that house to your daughter so she can live in it, and you give it to her. Say, hey, I got enough. You can have the house. Okay? You die. She now sells the house for the $700,000 it's worth when you die. She doesn't get to step up in cost basis because you gave it to her before you died. So in that example, if she decides to sell it right after you die for $700,000, she's paying taxes on that $500,000 in gains. So the point is, if you have assets that have appreciated, don't make those be the ones that you're going to give away. Give away the assets that haven't gone up in value. Okay. So IRA planning. In 2020, the Secure Act took effect. Secure Act allowed for or changed rules when it came to your beneficiaries inheriting IRAs. In the past, if a beneficiary inherited an IRA, they can stretch it out over their lifetime. So if you were 40 when you inherited it from your parents and you lived another 40 years, you can let that IRA keep growing for the next 40 years while you're alive, only taking a little bit out of it each year. Okay. What the IRS did when they came out with the Secure Act, and said, hey, now kids, most of them, and there are exceptions, but most of your kids, when they inherit it, are going to have to take it out over 10 years. Worst case. They can take it out faster if they want, but they can't hold it longer than 10 years. The reason the IRS did that is because they want to be able to tax it. If you could keep it in there for 40 years, they never get to, they have to keep waiting to tax it. So the IRS said, no, we're not doing that. You got 10 years now because they want you to have to pay taxes faster. Okay. I think I saw a question. Let me check that real quick. Okay, so question Sean asked, when trading stocks, is it better to not have an IRA stock account versus a regular margin account? So there's pros and cons each. With your IRA account, the good thing is you get to keep deferring those taxes until you retire and take the money out of them, and then you pay taxes. And for many people, they're going to be at a lower tax rate because they're not earning as much income. Maybe they had a job before and now they don't, and they're just living off their investment. So maybe their income is less. And so you don't have to do pay taxes on every time you make sales. I have a friend who's a trader, and he had an account, a non-qualified, like a regular margin account. And he was doing like 30 to 40 trades a day. And he ended up at the end of the year, he got it was 6 boxes of trade confirmations on his 1099 that he had to provide to his accountant, 6 boxes of them. And so I talked to him and said, look, if you're making all these trades, do it in your Roth, do it in your IRA so that you don't have to register all those trades. And then you only pay taxes at the end when you actually take them out. Because with the IRA, you only pay the taxes when you take it out versus in your margin account. with the margin account, you're going to have to pay taxes as you make trades. And if you're making trades regularly and you're holding the stock for less than a year, then it's going to be short-term capital gains, which is ordinary income. Okay. Danielle asked, if you inherited an IRA prior to 2020, are you grandfathered in with the old law? Yes. The new law didn't take effect till 2020. So for any inheritance, it's 2020 or after. Any inheritance 2019 or prior, get that lifetime stretch. So good question. Oh, sorry, I didn't see that. Snook, go ahead.
Yeah. So you're a certified financial planner, yes?
Yes.
Okay. So like with how people deal with taxes, it's you want to have a tax strategist, you want to have a CPA, you want to have this, blase, blase. With setting up a trust, who do you want to have on your team and to consult with to deal with your own the nuances of each detail of how you want to set? Who is it best that you need to deal with for that?
So for setting up the trust,
Yes.
yeah, you're gonna want to have all three, your tax person, your financial advisor, and your attorney handling that, because they're going to affect each other. Like there's tax implications.
Well, what kind of
You want to
attorney?
have
'Cause
those conversations together.
you want to have
Oh,
a
so there's great question. Yeah, so it's an estate planning attorney.
okay, an estate
Estate,
planning attorney.
ESTATE. Yeah. So let me.
Okay.
I just put it in there. Estate planning attorney.
Okay, great. All right, thank you.
No problem. Danielle, great question. That's going to be one of my next bullet points. She's asking about Roth conversions, so I'm going to get to that in a second. We're almost to the end here on that, so I'll get ready to get to that in a minute. Great question. All right. So because of those laws that make it where you got your tax planning becomes harder because of the Secure Act, we want to look at and figure out what's the best thing to do. So should you start taking out distributions before you're required? So with IRAs and Roth IRAs and such, at 59 and a half is when you can start taking money out without any penalties. But the IRS also says for your traditional IRAs and your retirement accounts, your 401ks, 403bs, thrift savings plans, whatever type of retirement account you have, the IRS says, hey, starting at 73, you have to start taking the money out. Why? Because they want to be able to tax it. While sitting in those retirement accounts, they're not getting to tax it. Okay. So sometimes it makes sense for you to start that distribution before 73 so you can start taking it out over a longer period of time and take out less money each year versus getting to 73 and having to take out bigger chunks and therefore putting you in higher tax brackets if you don't need to be. Okay. So should you do Roth conversions? And Danielle, this goes to your question. So with a Roth IRA, as long as you've had a Roth IRA for at least 5 years and you're 59 and a half when you start taking distributions, the money that comes out of the Roth IRA is tax-free. Okay. So it's great. You put $5,000 in the Apple stock 25 years ago, and now it's worth $500,000, and you're 59 and a half, and you take the money out, that $500,000, tax-free. Okay. So Roth IRAs have some good benefits. A Roth conversion allows you to take money out of your pre-tax, your traditional IRAs and 401ks and retirement plans, and convert them to a Roth. The downside is you got to pay taxes when you do it. Okay. And your tax person, like we do when people come into the office, we have software that we help them. And I don't do taxes, I just do tax planning. We'll help them figure out, hey, this is the right amount of money to do this year for Roth conversions based on your income. Okay. Because you don't have to do your whole account. You can do it in chunks based on what you have going on. And so a lot of times we'll say, hey, oh, you're going to retire in 3 years and your income's going to drop. Let's wait 3 years to do the Roth conversions when your income drops, so that when you take the money to do the Roth conversions, it's going to be a lower tax bracket because you have less income. Okay. So you can control when you do your conversions. But a Roth conversion could make a lot of sense, especially, if the money is going to be there for a long time. Because with the Roth, your beneficiaries still get to inherit the IRA, the Roth IRA, tax-free also. So if you set up that Roth and you have it 40 years and then you die, your beneficiary gets to keep it for another 10 years, and then they have to, same thing with the Secure Act, they have to cash it out at the end of the 10 years. But they would have had all that, your 40 years plus another 10 years for it to continue growing tax-free. And if you guys being traders and investors know the power of compounding interest, those numbers can start growing quickly. Okay. Should you fund life insurance with your distributions? With their IRAs, a lot of times we'll use life insurance for tax planning. So we'll say, hey, you're going to have to take these distributions, or hey, you have $500,000 in your IRA, and we know that's probably going to grow by the time based on your age now, maybe that's going to grow to 1.5 million when you die. Well, when you die, that 1.5 million becomes taxable, so your beneficiaries are going to lose $600,000 in taxes. Maybe we want to take out a $600,000 life insurance policy to cover the taxes that are going to have to be paid. Okay. So again, there's life insurance we can use life insurance to do some tax planning. Should you use your IRA to fund long-term care? A lot of people, their biggest concern in retirement is what happens if they need long-term care. Okay. The thing is we can use some of your IRA money as a way. There's types of investments that we can set the money aside in the IRA, and it will help cover the cost of long-term care. So we can plan and use that IRA for long-term care to take care of it. Highly appreciated annuities. If you have an annuity, when you pass, the beneficiaries is treated like an IRA account or retirement account. They have to take it out as ordinary income, and they usually have to do it within 5 years. We can do what's called a non-qualified stretch and stretch out the distributions from it to minimize taxes. Okay. You want to make sure your investment portfolio, if you have stocks, is you're managing them efficiently. If you own mutual funds, you may be getting 1099s even though you're not spending the money. So you want to look at it and see, hey, do I have the right investments based on my tax situation? Maybe, again, holding stocks for longer than a year. If you're trading stocks and you have a stock that you've been holding for 11 months, maybe waiting one more month to sell it maybe beneficial because you're going to get better tax treatment doing so. Okay. I'm skipping that because we're running out of time. All right. So holistic approach. I see there's a couple questions, and I'm wrapping up here, and then we'll get to these questions. To estate planning, again, you got the legal side. That's where you have the documents, the titling, the beneficiaries. Okay. You also have the financial side. That's why you make sure you have the right tax. You've done the tax planning. You have the right types of investments. You thought about long-term care because long-term care expenses could be what really jeopardizes your portfolio. Okay. The biggest risks of your estate, we talked about probate. We talked about taxes, healthcare, long-term care. I mentioned, again, if you have to go to a nursing home and you have a memory care issue, like for Alzheimer's, that could be $10,000, $12,000 a month that you'd have to spend down. Inflation, things are not as, usually what we see is when people get older and they get closer to retirement, they become more conservative. And if they become more conservative, they're not keeping up with inflation because their investments don't do as well in market volatility. So summary and takeaways as we walk away. Everyone has an estate plan. It's either the one that you choose or it's the one the state's going to give you. Because remember, there's intestacy laws. They're going to give you the plan if you don't have one. Okay. Plan as if you're going to die today and don't overthink it. Snook, I started a youth football program down here in Tampa, and one of my coaches was driving his son to school, had a heart attack and died. Okay. And so if you've gone this far without your estate plan, get it taken care of. It's a process, not an event. Like we talked about before, things change. So you may have certain people as beneficiaries, and again, people pass away, people get married, babies are born. So that may change what you're trying to do. Okay. Probate can typically be avoided. We talked about many ways to avoid probate. Good estate planning, going back to your question, means you're a tax person, you're legal person and your financial person should be talking. Harbor pilot, this is normally when I'm doing this presentation in front of a group of people and I'm trying to close them and give my pitch. I give this analogy, but basically the analogy is saying, hey, you're coming to a harbor in your life, which is retirement, and the captain of the ship who got to the harbor may have been great in the open seas, but doesn't mean he's the right person to bring the boat into the harbor. If you've ever been on a cruise, the harbor pilot has to come out to the boat and bring the ship into the harbor because they know that harbor. They know what's going on. Okay. So I'm not going to go through that close that I would normally give because, as Sean said, this is not a pitch thing here. Just wrapping up. Oh, I do like to use this little quick thing is to get people to think. So say you invested $50,000 in the S&P 500 in 1984 and you got amnesia, got in an accident and got amnesia and forgot about that money. In the end of 2024, you were cured and you remember that account. How much do you guys think would be in that account? So 50,000 invested in the S&P 500 in 1984. Go ahead and give me a couple guesses in the chat. Let's see if I have anyone put some guesses. I'm going to answer questions in a minute, but almost done. At 5 million, okay. Any other guesses? 1.2? 4? All right. Answer is $4.5 million. That $50,000 would have grown to $4.5 million if you did nothing. You just left it sitting there. And I equate this, and I do this as part of the harbor pilot discussion I'm having, is because the captain of the ship had the easy part of getting through the sea. The harbor pilot, now that you have this 4.5 million, your retirement harbor, need to know what they're doing with it. So that's why you want to make sure you choose. So going back to your question, you choose the right type of attorney. You choose a financial advisor that focuses on the tax planning and the estate planning implications. Okay. Again, we got to deal with the IRS. As you get closer to retirement, you have less time. Again, I'm the harbor. Again, this would be my close if I was doing this in front of a group I was trying to pitch to. I'm the harbor pilot. I'm the one who's going to bring you through that harbor of retirement. Yeah. Here's the little pitch as Sean mentioned, I'll give at the end. We've partnered up with a program called Estate Guru. It is a national company. The only state they can't do business in is Louisiana because Louisiana has different laws. They have unique laws, but all the other states they can do business in, and they can do a trust package. The trust package includes the trust, the wills, the power of attorneys that we discussed, the healthcare power of attorneys, the living wills. Okay. We can help have a discussion with you on titling and beneficiaries, and that program is $1,699. Okay, $1,699. If you ever talk to an attorney about a trust package, it's usually considerably more. That's a revocable trust. It says starting at, the reason is if you have properties and you want them to prepare the documents to put the properties into the trust, they charge $199 per property to do that. So if you have like one house, there's another $199 if you want them to do it. You could do it on your own if you want. If you have two properties, again, $199 each. I will say sometimes people come into the office or they call me to have a discussion on this. And sometimes what they're trying to do, what they're trying to accomplish is more complicated than what Estate Guru can do because it's a software that we use and then it gets once we enter it in, it gets assigned to an attorney to verify everything. But if what you're trying to do is more than what the program can do to customize, then it won't work. And then at that point, I will tell you, hey, go see an attorney in your area, or I can give you some names if you're down near me. But that is something. This is a program that can work for many people. All right. This is just. No. Oh yeah. One-time fee. I thought you were. Well, sorry. I should have waited till you finish. Yes, one-time fee to set everything up. Okay. When you have a trust, if you make changes, they charge for changes, and right now they charge $199 for an amendment. So if you need to change your beneficiaries in the trust or change your will or whatever, they charge $199 to make changes. Okay. But if you don't have to, if you're not making changes, you don't have to every year pay $500 or $1,000 to keep everything active. The trust is active. Once you die, it becomes irrevocable. Going back to to the original question, I think it was Snook that asked. It goes back. It becomes irrevocable. Then you have to file tax returns and stuff like that, and there could be some costs, not for the trust company, not for Estate Guru to do the trust, but you're going to have to do some trust, like there's stuff the trust has to do, and there may be some cost to that. But while you're living, that's a one-time cost. Okay. And so again, we thank you guys. If you guys would like, I'm going to finish up here on my screen. It has my information on it, so you can call us. Let me go back.
What if you have properties in Louisiana, but you don't live in Louisiana?
So they should be able to put those properties into the trust. But yeah, they won't be able to make them or do anything in the trust. They should. We can confirm that. I can confirm that for. That was you're the first person that asked that to me.
Okay. All right.
I can do that and check.
What's the name of the company?
The name of the company is Estate Guru. I will say if you go, yeah, Estate Guru. I will say if you go online and look, there is an Estate Guru that's in the UK. Totally different. They do like real estate stuff. Nothing to do with this. This is Estate Guru is a US based company that does estate planning. So just make sure if you're doing research, you look up the right Estate Guru, because I've had people call me and ask me about the other one, and then that other one that I've looked at, or I've looked at them, they have a lot of complaints. Has nothing to do with this one. They're two totally different things, not in the same country, not doing the same line of business, nothing.
Okay, and if we go ahead.
Yep. Yep. Yes, if they want help with the financial planning aspect. Yep. Correct. Well, no, because the Estate Guru would handle the estate attorney part of it. They assign, and that 6099 includes their tax person. Yep. Yep. That's the conversation, and I can have, as part of the discussion, I can have conversations with their tax person as we're looking to set these things up. Okay.
And if we wanted to, like, if we wanted more question, like, to before we decided to go, say, with a State Guru or with you or whatever, what do they charge to, if I want more in depth of a conversation or like a one-on-one before I decide to choose to go with you guys? What do you guys charge for that? Like, do you guys charge per hour with the conversation,
So
or
we
how does that go?
do a 45-minute free consultation to see if Estate Guru is even a good fit for you. Because I have a lot of people that I say, hey, what you're trying to do, Estate Guru is not the right answer. We need somebody more like that can customize the trust package and stuff like that. And that, if that happens, I don't get anything out of it. So I'm not trying to upsell you. I'm not trying to get you to spend more money, but I want you to do it the right way. And if Estate Guru can't do that, I'm going to tell you that. And so
Is it going to be the same type of conversation we just had, or will it be a little more in depth?
no, because what's going to happen if you schedule that, call us to schedule that appointment, my assistant will send you an email with a list of all the documents and information I want you to have before we meet, so that we can have a one-on-one conversation, and I can look over your stuff. That way, as we're having the discussion, I can give you more specific answers than here. It's more general. And some of what we have to ask, depending on where you're at. So for you, it's a lot easier because you're in Florida and have the laws. I know the laws of Florida. If you're outside of Florida, some of the stuff I may have to get the State Guru involved earlier to answer some questions if we need to. But in Florida, I can handle a lot of handle a lot of the questions.
Okay, so I would have to go through a state guru to set this up, or do I go through you?
No, you go through me. You'd give us a call, and I'll go
Okay,
back to the slide. Let's see here. Let me go back to my original slide.